Good morning, everyone. As you come to law school and make your way through first year, you're struggling to understand two things, or learn two things, one of which are the rights that people enjoy and the obligations that our law confers upon them, but also the procedures to put those rights into effect for clients. And after you finish your studies at law school and venture out into practice, you're going to struggle as you try to figure those procedures out and put them to work and get better and better at it and learn from those who've been doing it longer than you have. But as you do it, you're going to look around and see that there are some real inefficiencies and troubles and difficulties about the way we sometimes put rights into effect, processes for bringing claims. It's rare indeed that you will meet a human being who looks around and sees those problems, but doesn't just complain about them, comes up with a dramatic new way to fix them. And you're going to hear from that person of that sort just now. Lainey Feingold is a graduate of the Hastings Law School in San Francisco, graduated in 1981. She practiced in the labor law field and the civil rights field, and then went to work for the leading disability rights community organization, the Disability Rights Education and Action Fund, or DREDF, in Berkeley. That's the hotbed of cutting-edge work. That's the birthplace of the Americans with Disabilities Act, was DREDF, and they're doing major leading work in the United States in this area. She then went out 20 years ago on her own and embarked on a whole new approach to advancing disability rights claims that she's going to describe to you. She invented it, she used it, she succeeded with it, and she wrote a book about it that was just published by the American Bar Association. And as she talks about it, I encourage you to think about two things. One, as she describes the many wonderful examples, think of the imbalance of power in those cases. The largest government agencies and corporations that she faced, versus on the other side, her clients, either individuals or disability organizations, nowhere near as resourced or able through traditional litigation to take on a major multi-year and expensive legal battle. That's the first thing I encourage you to think about. And the second thing I encourage you to think about is listen to how Lainey has transformed the role of the lawyer as a problem solver. In litigation, in civil procedure, we're warriors. We do combat. It's us versus them. We win, they lose. And we are more likely to win if we can bludgeon them even more with as many legal tools as we can marshal. Lainey's offered a different approach. Ladies and gentlemen, give a warm Osgood Hall Law School welcome to Lainey Feingold.
Good morning. Thank you. It's really great to be in Toronto at Osgood. I really want to thank the school and your professors and your dean for inviting me. I live in Berkeley, California. It's my first time to Toronto, so I'm really glad to be here. I have up on my title slide two things I want to point out. One is my Twitter handle, @LFLegal. There's not enough people in our profession who are on Twitter, and David and I are two of them, and I really have to tell you that it has really enhanced my practice of law because it has enhanced my community. And I'm a disability rights lawyer, and it has connected me to disability rights advocates all over the United States for sure, all over Canada, and all over the world. So if you're on Twitter, I invite you to connect with me. And also my website, lflegal.com. Most likely you're going to have questions after this. Please be in touch. You can contact me through there. I really, I'm happy to be a resource to any of you who are interested. So, the title of this talk is Structured Negotiation, a Winning Alternative to Lawsuits. And that's what it is, and that's the title of my book. So let's get to it. Let me see, where do I point this to move the slides? To the screen? Okay, so what is structured negotiation? I start with this picture of a handshake and a win-win. Because like David said, too much of law, really too much of life is kind of I win, you lose, I only win because you lose. And this is a process that is focused on win-win. And at every step, which we're going to talk about throughout the presentation, at every step, we're needing to remember, as lawyers, as clients, that we are working on win-win. And sometimes it's easy, you guys are lucky to be starting law school in a period where alternative dispute resolution has come to the fore, and you have a great program here, because I've been a lawyer for 35 years, and you can really get steeped in the other way of doing things. So I really encourage you to think about whether win-win suits you, suits your clients, and suits the issues that you're going to work on, whatever your area of law is. So what is structured negotiation? First and foremost, it's a lawsuit alternative. It's a structure, it's a process, and we'll talk about that in a minute, instead of filing a lawsuit. So that's the first thing to know. The second is very cost effective. And those of you who are already working in the legal field, or pretty much everyone knows, it's very expensive to do law the way law is set up. So this is a cost-effective process, and we'll talk about the cost savings all along the way, as well as relationship building. It's a process that strives to build relationships from one client to the next between lawyers and clients. So win-win lawsuit alternative. What is the background? I want to just give you a little background before we talk about, what exactly is this process. In the United States, I'm a disability rights lawyer. I've represented the blind community since 1995. And when I say the blind community, sometimes I represent blind clients and they say, I don't really like that word you use, blind community. I don't feel like I'm in a blind community. I'm just a blind person in the community. I use the word blind community because I represent blind individuals as well as organizations that represent blind people, like nonprofits. We have, in the United States, the American Council of the Blind. We have state organizations. We have service organizations that are primarily geared towards, with, and by blind people. So that has been my law practice since as David said, I work in a disability rights nonprofit. And when I went out on my own since 1996, I've only represented blind people and blind organizations. And we use this process of structured negotiation. I'm going to just tell you, just to get a brief idea of what its power is, I want to tell you what companies we've worked with, what government agencies, what issues we've worked on, and then we'll dive into how did exactly we do it. So what kind of companies? We have worked in structured negotiations with some of the biggest private companies in the United States. And every name that I put up on this slide and I mentioned is a company that said yes to a collaborative process. So we've done work with CVS Pharmacy, we've done work with Major League Baseball, Bank of America. We've done maybe 25 different banks in the United States, Wells Fargo, Citibank. And in our country, and I'm sure here too in Canada, many of these institutions have reputations for fighting hard when a lawsuit's filed, for not settling, for trying to drown an individual person in paper. But structured negotiation is a different process, and all of these companies have said yes to doing things that's relationship building and collaborative. So Anthem Blue Cross, which is about big health insurance company, Cinemark is big movie chain company, Weight Watchers, we all know Weight Watchers. And this is just a sampling. I've done about 75 cases. Some people are laughing. I don't know if it's at Weight Watchers or it's a private joke, but I'm just going to play off of that to say, when I first started in this work with blind people, I thought accessibility and privacy was all about, we started in finance and working with banks, and I thought it was, access and civil rights was all about serious things like right to your money. And when we were approached by women who were blind who didn't have access to the Weight Watchers tools, it was one of the most popular cases we did when we were able to work with Weight Watchers to make sure their online and their mobile tools were usable by blind people. Same with Major League Baseball. I mean, I'm not a baseball fan. I almost didn't want to do the case because I thought, how important is that people have access to Major League Baseball online? But the blind fans, and all of my work is client-driven, convinced me that, people care about baseball kind of more than they care about their financial, bank account. And sure enough, Weight Watchers and Major League Baseball were probably two of the most, I don't want to say successful, but popular cases in the community nationally. And in the book, I tell stories about the baseball fans. And one of the guys says, everywhere I go, no matter what else I've done in my advocacy career, people are always talking about, it's so great we have access to baseball. So, so those are some of the kinds of companies. It's a process we've also worked with government agencies on. We did work with the city of San Francisco. This is a picture of buses in Houston. We did work in Houston, Texas. And we did work in I didn't personally do work in Denver, but this process has been used in Denver. So all over the country, all different kinds of companies, all different kinds of government agencies have said yes to not being in a lawsuit, to being in this process. So what kinds of issues have we worked on? My work in this field started with ATMs that talk so blind people can use them. And that's what a picture is here of a blind woman using an ATM. When we started, there were no ATMs in the world that a blind person could use. And we'll talk in a minute about how it came. Well, I can tell you now that, we talked to blind people. Nobody could use an ATM. There was Bank of America, Wells Fargo, and Citibank in California. We said, we should file a lawsuit about this. But you know what? It wasn't the right tool. And instead we said, well, maybe we should talk. Maybe we should write these banks a letter and say, do you want to work with us collaboratively in relationship and try to solve the problem of ATMs so blind people can use them? And much to our surprise, every bank said yes, and that was the start of this process. At the time, we didn't call it structured negotiation. I didn't have the idea of a book because I didn't know it was really a process. But we started working on that issue, and it was so successful that blind people from around the country started coming to us with other issues and saying, wow, I don't really want to do a lawsuit, and you got amazing results with these big banks. Could you help me with this and with that? And so some of the other issues, web accessibility, which has to do with things like making sure there are captions on videos, making sure that blind people who have technology that speaks the computer screen aloud can get that information because things are coded on the back end. We don't have time today to go into the details of digital access, but I can just tell you guys are all going to be lawyers, and you're all going to have websites and mobile apps and use them. So no matter who you end up working for or representing, you're going to need to understand how technology really needs to be made available to everyone. And it's really been my privilege over the last 25 years to be using this collaborative process to explain to all these big companies and government agencies, here's the technology that blind people need to be able to participate fully. So we worked on websites, we worked on mobile applications, we worked on accessible pedestrian signals so blind people can safely cross the street, audio description in movie theaters so blind people get enough information to fully enjoy the movie, talking prescription labels. I guess I put the picture of the computer on there twice to show. I've done a lot of cases on web accessibility. The talking prescription labels, we did use this process of structured negotiation with all the large pharmacies in the United States who said, yes, we'll skip the lawsuit and work in collaboration so blind people can safely take their medication. Tactile keypads, so when blind people use a debit card, they don't have to share their PIN number and they can do it independently. So all of these issues came to us through clients. And as I said, I'm a client-driven lawyer, and really that's really what the profession should be about, whether you're representing businesses or governments or individual people. It's all about what are the clients. And when they come to your office, they're going to tell you what the problem is, but they don't necessarily know what path to take. And I think that's one of the biggest kind of messages I have is that as a lawyer, we need to be creative about figuring out what is the best path for this client to get to the resolution that they want. So in all these cases, ever since a bank said yes, much to our surprise, I have used this process of structured negotiation. I have taken that path instead of a lawsuit path. And I just want to say up front what is the basic structure of it, just a quick overview, and then we'll dive a little deeper. So you guys have taken almost what month is this? Almost a whole year of civil procedure. So you know that usually things start with a complaint or a claim that is filed. So in structured negotiation, we're basically operating outside the court rules, outside the civil procedure rules, outside the structure that has already been established. And let me just say at the outset, because I know this is being videotaped, and I just remembered to look at the video camera, lawsuits play a very important role in society in the United States. And this book is not about saying lawsuits are bad, especially now with our new federal administration. As you know, we have a very big problem with the federal government, and our only hope seems to be lawsuits. And we've already made some success with getting a court to say, no, that Muslim ban out. That's happened yesterday. So, I said in the book, and I was concerned, when you write a book, it's like people are on your shoulders. What are they going to think of this? I don't want anyone ever listening to me in a talk or who reads a book to think that Lainey Feingold thinks lawsuits are bad, because lawsuits can really advance civil rights. But they're not the only path. And that's what these 20 years of practicing in a different way have taught me. And the path that I am using and that I'm teaching about starts with an opening letter. And we'll talk a little bit more later about what goes in that letter, but it's not a complaint, it's a letter. And after the letter, it's a ground rules document, because we can't turn to court rules. We don't know, when people have to file something or what's confidential, or, there's not a set of rules. So the parties themselves are working on ground rules. We do information sharing. I don't know how detailed it is in Canada, but in the US, oh my God, there's a million, not only ways to get information, depositions, interrogatories, written questions, site visits, all of which are very formalized. You have to write them up in a certain way. You have to ask for certain kinds of information. But there's so many ways to say no. In the process of litigation, there's a million ways to say, motion to dismiss, motion to, you don't have standing, you're not in the right venue, you don't have the right to ask for this information, you've asked too many questions, you haven't asked enough questions, you didn't ask the right questions. So we're skipping that whole discovery process, not to say it's not important, and you guys really need to learn it in law school, but when you take a different path, you don't have those rules. So we have information sharing, we use experts in a very different way that we'll talk about. It all leads to a written settlement agreement. In the United States, most legal resolution starts with a lawsuit, but most end with a settlement agreement. And I think over 97% of the civil cases in the United States end up in a settlement agreement. So we end up in a settlement agreement too. It's just that we have not spent so much money and created so much conflict between the parties at the time they sit down at the table. We have a settlement agreement. They're very similar to settlement agreements. We do media after the agreement is settled, and so we have something good to say instead of before, when all we could do is criticize, and we'll talk about that when we go more in depth. It's just trying to give you a high-level overview of the steps, which is a structure, which is why we ended up calling it structured negotiation, because we really want to convey the method. This isn't some casual conversation. And like I said, I started out representing individual blind people and organizations. And a lot of nonprofits, everybody wants to get to the resolution, and so people start having conversations, negotiations, it's casual, and then at the end of the day, maybe you don't have a settlement agreement, your clients haven't gotten paid. Excuse me. So we called it structured negotiation to say this is a structure. This isn't just some casual thing we hope will turn out right. There's an actual blueprint to make this happen the way it's happened for the last 20 years. So we do media and we do monitoring, and the monitoring makes sure the settlement agreement happens. And the final step, the final stage, the final element is really, if I was better with the PowerPoint, I could weave this last element into every single other element, which is the attitude. The attitude that you have to have when you're working in collaboration instead of in conflict. And in a lawsuit, you can be nice to your opposing counsel, and many people, most people are. But But the very nature of the system is to put you in opposition. The very structure of it defines how you're talking. To do a process outside the litigation system, where it's driven by people actually talking to each other and forming a relationship, you have to have a certain attitude. And if you're the plaintiff's lawyer, you have to have it most of all. And that attitude includes patience and kindness and trust, not making assumptions. You know, in the U.S., we're so, well, you know, you're a lawyer, you think the other side's trying to screw you over. It's just like a natural thing when you have a binary dual system that what you want, you think the other side doesn't want to give you. And you have to change the mindset when you're engaged in a process that is not that. It's really depending on working together to find a solution. So that's the overall structure. How do you know it's the right strategy for your case? Well, again, it's all about the client. So what claims do the clients have? In the book, I go through the types of cases, like I just mentioned briefly, that we've worked on. We're really hoping that this is a process that can really have widespread use. It's just like my honor that it was birthed in the disability rights movement, but I was excited last week. A patent lawyer called me and said, I read your book, someone gave it to me, and I think like it might be relevant to patent lawyers. I'm like, all right, I don't know anything about patent law, but she wanted me to do a webinar, which I'm doing next Tuesday. So I'm really eager to get the feedback on that from that sector. Because as I said before, lawsuits of course play an important role, but in so many sectors there is an impetus to try to find ways to do things that are more, for lack of a better term, open-hearted and less conflictual and more cost-effective. So you have to see what are the claims and are they going to be suited. You also have to see what the attitude of the clients are, because it's not just your attitude as a lawyer, but you need to work with your clients to have them understand, if you go into a collaborative process, it's going to be different. It's going to feel different in terms of timing. It may take less time, but the client might have to be more involved sometimes. And also, some people are not suited for collaboration. Now, I think most people can learn to be suited. I can tell you that I'm a much more collaborative person than I was when I was in your seat in law school. And as David said, I was a union-side labor lawyer when I first got out, and that's all I wanted to do. It was also very, it was mostly arbitration and not litigation, but it was also very one side or the other side. But when you practice in this way and you want to be this way, then you become more collaborative. And most 90% of my clients come to me because they know this is how I practice. But like I tell a story in the book, when I interviewed people for the book, the clients, and I said, well, why do you like structured negotiation? Is it suited? And most said, oh my God, yes, I'd never do a lawsuit. I don't like conflict. I like to work things out. And one guy said, hell no, I'd rather just sue the bastards. But, I'm a blind guy and I've seen the success you've had. So yeah, I want to do it. So you got to work with your clients and you got to figure out if it's the right process and right approach. Now I bring out my prop of my toolbox. This is very important. Which tool? This is kind of like the path idea. I carry around this toolbox. Could be corny, but I like it. To show that when we're lawyers, there's many tools available to us. And I like the next slide too, because when all you have is a hammer, and there's a big picture of a hammer here that's on a hardware store on Haight Street in San Francisco, when all you have is a hammer, everything looks like a nail. And that's why I have this hammer, because we're mostly trained in law school and as lawyers to say, someone has a good claim, I have a good lawsuit. And those two things don't have to go hand in hand. Someone can have a good claim that is better resolved in an alternative process. And in case I forget to say this, I just want to say now that structured negotiation wasn't born as structured negotiation. It was born out of those first letters where we said, hey, do you want to work on ATMs? And suddenly we realized we had a thing and we named it, and, it's changed over time. So, part of the reason I want to share the book, part of the reason I wrote the book is because there's many other ways to do things besides structured negotiation. Besides mediation, which has been around longer, of course, than structured negotiation. And I think if we just remember, not so much, I have to do structured negotiation or a lawsuit, but that we have a lot of tools. We are so privileged to become lawyers. We have so many tools at our disposals, and don't forget that when all you have is a hammer, everything looks like a nail. Remember my toolbox. If you don't remember anything else, like that lawyer came from Berkeley with a plastic toolbox full of saws and what's this? A wrench? Is that a wrench? Yeah. Same with mediation. I'm sure most of you are familiar with mediation. Maybe you've participated. In the United States, and mediation is a great thing, but most people don't use it till they've already spent time and money fighting with each other, and then they go in, and the mediator has to be the third party and kind of get them together when they never really tried to get together on their own. We have used mediation in structured negotiation 4 or 5 times over the 20 years I've been doing this work. I've done about 75 cases in the process myself. Other people have used it. We've only had to bring in a mediator 4 times. But we could bring in a mediator more often, but it's an example of the tools. They're available to you, they can be used at different times, they can be morphed. You can take one part of a tool from one place, one part from the other. I guess the main message is like, we have the privilege of being creative, so we should be creative. So how do you get started? The opening letter, like I said, instead of the complaint, is the opening letter. So the structured negotiation opening letter is all about language and tone. And one thing, if I wasn't clear before, I want to say that structured negotiation is a process to resolve legal claims. So your client has to have a legal claim. It's not something, there's no claim here, I'll just try this California thing called structured negotiation. No, it is a real process that has worked with, as we said, the biggest companies in the United States because people had real legal claims. So we put the legal claims in the letter, but we don't have to, it's kind of the hammer thing again. We don't have to hit people over the head with it. You don't have to say, you're a bad person. Obviously you wouldn't write a demand letter. You wouldn't write a letter and say, you're a bad person, but that is the tone, that is a feeling of most letters. In the United States, many people do write what we call demand letters before they file a lawsuit, but as a friend of mine I quote in the book said, I used to write demand letters, but I would always have the complaint ready to go because I knew it was kind of bullshit and that it was just like a formality. This is a real effort to build trust and to get whoever you're writing to into the process. So you need to write it, you need to be friendly, you need to try to find something good to say about the person or the company you're writing to. And even the biggest companies, Walmart, Bank America, American Express, these companies we've worked with, there's always something you can find that is good. And I think that creates an environment in the letter where the company says, these people are being truthful with us. Yeah, we do have customer service. We don't have talking ATMs, but yeah, they recognize we have customer service. Or I did a negotiation with Charles Schwab, which is a big financial institution. They were very generous financially. They had a foundation. They gave money to a lot of disability groups. I put it right in the letter. I said, you've been a great company for disability groups. You've given them, you've been very generous with your finances. We hope that same generosity can be directed towards resolving the claims in this case. And even if, now some of you may be thinking politely in the back of your heads, that sounds crazy. I'm sure the people reading the letter at Walmart don't care if we say something nice like that. But you know what? It affects your approach to the case. If you're thinking that, hey, I'm trying hard to get them to engage because it's better for my clients. And that's the last point of the letter. And that is the last point of, you can be a strong advocate and you can still be a peacemaker. And I didn't really realize that till I was writing this book, because I have always been a plaintiff's lawyer. I either represented labor unions or minorities and women in traditional civil rights or disabled people. I was never wanting or interested in working anywhere else but as an advocate. I never saw myself as a neutral. I've never been a neutral. But in writing this book, I realized you can be a very strong advocate and still consider yourself a peacemaker, still consider yourself a collaborative person, because it serves the advocacy goal. It serves the advocacy goal. Too much of traditional lawyering is like, and the mass media feeds this, television, the best lawyers are the men in suits that bang on the table, that kind of thing. Not so. And I'm hoping that the book is going to encourage people to, to say, wow, there's been really big results here doing it a different way. So you write the opening letter, which in short form is don't demand, I got the guy on the table banging, but rather invite. And we actually say in the letter, we invite you to participate in a process. Not, we invite you to install 25 talking ATMs by January 15th or else we'll file a lawsuit, which is what most demand letters are. This is an invitation to participate in a process to resolve a claim that you have explained in a calm and kind manner. I'll just tell you one quick Canadian story. There's some Canadian stories in the book. I try to remember them for being here in Toronto, but one of the things about the opening letter is to try to create trust. And one of the ways you create trust is, like I said, by saying something good or by sharing information. Because so much of law is like, oh, you don't want to tell the other side anything because you're saving it for a judge. We don't have any judge, so we don't need to save it. So we were helping two blind businessmen in the East Coast get Braille credit card statements from American Express, and our client found out that American Express Canada was offering the statements, and even found the vendor in Ottawa who was making the Braille statements. So this is like a no-brainer. They can do it in Canada for American Express holders. What about U.S.? So we actually tried to call the company informally, couldn't get anywhere, so we wrote the opening letter, which you notice I don't call a demand letter, call the opening letter, and we said right in there, you do a great job in Canada. Like, can't you do the same for us? And we even put in the name of the vendor and the vendor's phone number. Like, here's your vendor, because the lawyer in the New York office is not going to know. They're not even going to know who to call to find the vendor. Here's your vendor in Canada. Why don't you call them, and then let's talk about how we can solve this problem for our clients. So that's an example of building trust in the letter. So here's a really important point I need to make that I had to learn, and I'm so glad to be sharing this with you before you get too set in lawyerly ways that are, inflexible. You got to be patient after you send the letter. You made up a date. You said, okay, answer this letter 20 days or 25, a month later, but there's no court rules, so there's nothing requiring the other side to answer the letter. So people often say to me, why does anybody answer you? All I can tell you is for every letter we've sent, we've gotten an answer, because that's kind of how human beings work when there's lawyers involved, which is why this is a legal process. But it can be very anxiety-producing waiting for that letter, because you think it's not going to come, and you know what? On the day you wanted it, it might not come. So it's really important to get the letter in the right hands. And oftentimes I'm on the phone a week before the due date that I have made up, talking to the administrative assistants, very important still, even though there's fewer administrative assistants, they are your ally in the legal system, no matter what you do, especially in structured negotiation. You got to find a way to get the letter in the right hands, and you have to be persistent. And I didn't used to have a picture for persistence, but in honor of what's going on in my country, I have the She Persisted picture of Elizabeth Warren for the persistence slide, because Elizabeth Warren has stood up to Congress in trying to fight the nomination, now the actual person who is our Attorney General. So you need to be persistent. And I like having Elizabeth Warren on the slides, because we got to be very persistent now in the United States in fighting the situation we have. So if we can be persistent there, we can be persistent when we send a letter, making sure it gets in the right hands and we get an answer. When you get the response, again, it's not a civil procedure thing, so you don't have an expected answer. You're going to get a letter. Don't expect to be greeted with open arms. This is my picture of someone with her arms wide open. Don't expect to be greeted with open arms, because the letter is primarily going to say, you're wrong, we didn't violate the law, we didn't do anything, you should have told us, we love your clients, but there's not a legal claim. That's what the bulk of the letter is going to say. And it'd be very easy at that point, and most lawyers would throw in the towel. Just say, oh, we got this letter so much, this isn't working, we should just forget this process. But no, you have to look for the slimmest of reeds. I have this picture with a bunch of reeds on a lake. The slimmest of reeds. We did negotiations with Major League Baseball. We wrote them a letter on behalf of the blind fans. The lawyer calls us up and says, we need an extra week to respond. We say, okay. always say okay. If you haven't been taught this in law school, anybody asks you for an extra week to respond, unless someone is, going to die or languish in jail, you should give the person an extra week. So, I don't know. Your professors can correct me if they don't agree with me on that. But so they asked for an extra week, and the day came, and the day went, we didn't get the response. Another chance to throw in the towel, like, oh my God, we gave them the week, they still didn't respond. But no, we have to be persistent. We call up the lawyer. We say, what gives? We gave you the extra week. And he's like, oh my God, I sent it last night, UPS. Let me, get the tracking number. Sure enough, came the next day, read the letter, blah, blah. We're not required to make our website accessible. We really like our fans. There were a million reasons for us to crunch up that letter and throw it in a trash can, because it really didn't look like they agreed with our legal theory. But you know what? In this process, they don't have to agree with our legal theory. They got to have some reason in the back of their head to want to sit down with you. And you don't have to convince a judge that they were wrong. You don't really have to convince them they're wrong. Oftentimes I say, thank you for your letter. We know we disagree on this point. Are you willing to meet with us? So with Major League Baseball, they said, after 5 paragraphs of no, 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 they said, but we're willing to meet with you and your clients. And that was the birth of an amazing relationship between blind baseball fans and Major League Baseball to make sure the mobile app was usable by blind people, the website of all the Major League Baseball teams were accessible. So don't throw in the towel if you don't get the open arms. Throw in the towel, or I have the road map sign, yes, go one way, no, go the other. So many chances. And one thing about writing a book, which I reviewed every case I'd done and talked to all the clients, all the opposing counsel, and I realized a theme was there were so many ways for this thing to fail. There were so many ways that this might not have happened. There were so many opportunities that we could have said no. We dealt with the credit reporting companies. There were 3 major credit reporting companies. I don't know if you have them here: Equifax, Experian, and TransUnion. Some say yes. And so there were 3 companies. They had big law firms, one at DC, 3 different time zones. It took, forever to get the first response. And we ended up, because we were patient and persisted, with a really great agreement where they fixed their website so blind people could get free credit reports. They're in Braille, they're in digital, they're in large print. That could have gone south so easily. I mean, that was one of the biggest lessons I learned, that if you don't stick with it, now I don't know what would have happened, because we don't know in life. You can't see what would have happened if we hadn't stuck with it. But we did stick with it, and it all worked out. So now I'm very big on, staying on the road, not throwing in the towel. You got to establish the ground rules. The ground rules are basically the court rules for structured negotiation. You list the parties. You list the topics for negotiation, the topics, not I need to have 1,000 talking ATMs, but topic, how will we improve ATMs so blind people can use them? It's more, you identify the issues and not deal with the specific results, because you don't have enough of a relationship yet to really come up with a conclusion. So you're identifying the issues, you do tolling, which means extending the statute of limitations, because again, you want to really protect your client's rights. There's nothing in this process that should make your client sacrifice any right to relief they would have if they had gone a different path. So we have to protect the time limits, because if if the cases fall apart, you need to have the right to use a different tool. You might have to use the hammer, but I want to tell you that in 20 years of 75 ground rules documents, there's only been one case where after the ground rules were signed, the case fell apart. So confidentiality, so people feel comfortable in discussing the negotiation topics. Attorney's fees, which is a way, whatever your attorney's fee relationship with your client needs to be protected in the ground rules document. Do you have an end date? And again, it's a process that's flexible and you can be creative. I don't like saying these negotiations will last for 12 months and then the negotiations are over, because you don't know what's going to happen. You don't want to create false expectations in your client that the case will be over. On the other hand, a friend of mine in Chicago who uses a process, he likes saying 18 months he likes saying 12 to 18 months because he feels it holds the company's foot to the fire. You can be creative. I have, examples of ground rules document in the book, but you can be creative because the ground rules have to work for everyone. And this is the first point at which you're really creating a relationship with the lawyer on the other side to say, what are the rules? What is the playing field that we're going to use before we bring our clients in to resolve this issue? So you have to resolve objections. I have the cute girl looking at the broccoli. She doesn't want to eat the broccoli. I like this picture because structured negotiation is good for the person you're writing to. It will save money, it will save time, it will save bad publicity, it will save heartache, but many lawyers are on autopilot. They don't see that. They don't want to sign the ground rules document. So you have to spend some time in resolving their objections. You have to try to build trust. We don't really have time to go. I have a whole chapter how to talk defense lawyers off the cliff and convince them it's a good process. But just know that is one of the stages. It's not going to be handed to you, and there's no court rules to say they have to be in the process. So it's up to us as advocates who think this is the right tool to be convincing. Another chance to say yes or no. Have to build a common understanding. So like I said, we don't have discovery, depositions, etc. The basic idea is in this graphic. The first picture is a guy trying to hide the ball with cups. Typically, that's how information is treated in a traditional legal setting. That the information is yours and you really only give it over when you have to. And it's hard for clients because most clients, it's a story. Their claim, we call it a claim, it's a story. To them, it's a story. They want to share the story. They want the other side to understand them. And that goes both ways. Even big companies, they've got their story too. They've got their reason why they can't do it, or they can't do it on time, or they can't do it yet. So information sharing in structured negotiation is more this. Cute picture, two kids sharing the ice cream cone. And it really helps make the process more client-centered and client-driven, where clients on all sides of the table have the opportunity to share information. You need to figure out, like people are always asking me, especially lawyers, they raise your hand, I don't think that's going to work because I don't think I would ever get the information I need. And I'm like, I can't predict the future, but I can tell you that it's worked for 20 years in these cases. And the way it works is we only ask for information that we think will help everyone. And we frame it. We need something from Weight Watchers. We need to know exactly their background of their platform and how they put their site together and what paper information they handed out. In a hospital, there's 1 million pieces of paper you get. And if you're blind, you can't see any of that. So I always phrase it, what information would be helpful for all of us to resolve this dispute? And what do you really need? When you have systems, like in the litigation system, that give you chances to ask for 1 million things and chances to say no in 1 million different ways, you can spend a lot of time and money on information. But if you think about what you really need, and you have a ground rules document so everyone's agreed to the process already, I can only tell you that 99% of the time you get what you need. So the meetings. We have structured negotiation meetings that are really the highlight of the process for me and for the clients. At their best, and I'm not saying every single case is a fantastic meeting, but at their best, they allow the parties to talk to each other, to share information, and to create empathy all around the table, to have an understanding of where the other side is coming from, so you will be able to negotiate a resolution that works for everyone. Now, yesterday I was doing a talk and someone raised their hand and said, how can you negotiate civil rights? And I'm bringing that up here because there are issues. When we talk about negotiation, we're not talking about meeting in the middle, in some mythical middle. There can be issues. We had marriage equality in the United States. It was a court decision. You can't negotiate a little bit of marriage equality, but many, many issues in disability rights have a lot of details that can be negotiated. So we would never negotiate, you don't have to have talking ATMs, or only half the ATMs have to be talking, but we can negotiate when, or what features for the first 6 months. Yes, some things cannot be negotiated, but most things can be, or have issues that can be. Experts. Okay, I only have a couple minutes, so I'm going to go a little faster, just give you an overview. Experts, the best thing, well, I think a lot of things are the best things about structured negotiation, but one of the best things is experts. I don't know how it is in Canada. In the US, one side has one expert, the other side has another expert, and the experts are fighting with each other, and you're spending time and money proving the other guy's a bad expert and your gal's a good expert. Not that effective and efficient. So, for example, we did accessible pedestrian signals with the city of San Francisco. In the United States, there aren't that many people who really know about accessible pedestrian signals. We wanted the city to have the best expert. We said to the city, let's just hire one expert and let's agree on who that person will be. And we always give the companies web accessibility 2 or 3 opportunities to choose an expert, 2 or 3 people to choose from the expert, because this is another kind of core thing. No one likes to be told exactly what to do. No one likes to have it shoved down their throat, they have to hire this person. So in this process, we can use joint experts. We've never had a problem agreeing. And also the clients can be experts, especially in disability rights. The clients often know more than the so-called experts on what they really need to get effective accommodations. So in the traditional process, clients have a role of plaintiff and they're not really trusted because they're the plaintiff and so they have an interest. Here, we've been allowed to have the clients really share their expertise. So the big picture of it is that lawyers can stay in the back seat and real relationships are possible. Not that it's not, lawyers play an important role, but as much as possible, let's get the clients together. Why does structured negotiation work? Structured negotiation works for a couple reasons. One, we can show, not tell. People can meet each other, and I've interviewed many of our lawyers that we've worked with on the so-called other side, and they have said, oh my God, meeting your client for 5 minutes was worth 100 pages of briefing. And that's one of the important things. We respect small steps. I have a picture of Harry Potter here because we were doing with a movie theater and we wanted 1,000 screens to have the special equipment for blind people. Couldn't really get the movie theater going, and our client was a little girl. She wanted to go to the Harry Potter opening. And we said to the company, please, could you just install this equipment for one theater and see how it goes? And they did. And the next day, we had the girl, could you please write an email? Oh my God, it was the best thing. They gave her the royal treatment. She could understand everything that was going on in the movie. I think, did I say she was 10 years old and blind? And she was just so thrilled. So I have probably 25 examples of how we started with small steps. We wanted 10,000 talking ATMs. When we got 5, we put out a press release. We appreciated the company. We wanted 1,000 accessible pedestrian signals. We started with 5. Again, put out a press release. And again, advocate as peacemaker. It didn't hurt our clients' claims. They got what they needed and they wanted, and they probably got it faster because we were willing to recognize that everything can't be done overnight. And structured negotiations is flexible and gives you the chance to figure out what those opportunities are. I'm out of time. I'm going to just zip through and see if there's one last message. Oh, I have one last message. I'm going to give you the last slide. I didn't get to talk about fear. I'll just show you my fear monster. If any of you are interested, I could send you an email. The fear monster represents that fear is a huge factor in negotiation. And I have so many examples, right? If we weren't willing to recognize fear and build relationships so we know what the other side's fear are and treat them as true fears and not to say that's baloney, this book wouldn't have been written. Okay, last thing I want to tell you is the last slide. Last slide. And the reason I want to show it to you is because my path to structured negotiation was very curvy. And you guys are starting your career. When I got out of law school, the only thing I wanted to do was be a union-side labor lawyer. I did it for 5 years. You know what? I didn't like it. Then I only wanted to be a civil rights lawyer. You know what happened? I did it for 2 years. I got fired. I got fired from a job. I write about it in the book. Just one sentence, but I got fired from a job. I needed work. There was a 4-month opening at a disability rights organization. I didn't know anything about disability rights. I didn't know any blind people. I didn't know any disabled people. I didn't know anything about anything, but I was fired and I needed a job. And that job was the start of my disability rights work. I did that 4 years. My kids were 7 and 10. I'm like, oh my God, I'm working too much. I got to go start my own practice out of my house. So I just want to thank you guys for being interested in this. And just remember, the path is going to be curvy. And if what you're doing isn't suiting you, take those twists and turns. Thank you very much.
Some amazing lessons include your career path can be as curvy and as amazing, and the sky's the limit. Second, it's amazing that disability rights, which 10 years ago would be something we would barely even mention in law school, Osgoode Hall Law School, to its credit, as an entire disability law intensive program, and is to be credited for that kind of leadership. Here it's an area where we can lawyers can generate incredible practical changes in the world for real live clients. Believe me, as a customer, as a consumer of those accommodations, they're huge. But also can become far from the outlier. Disability rights could be the birthplace of reforms in how lawyers can do their work that could transform things for all or many other important areas of the law. Finally, and Lainey's book goes into this in incredible and compelling detail. As you learn civil procedure, you're going to learn about the many motions we bring, the many complex clusters of procedures we generate. They are all money sucks and time sucks, and they tend not to actually yield a whole lot of justice for human beings. Those paying the freight may be happy if they wear the other side down, but we'll never see them as something that actually yields a whole lot more justice. Maybe sometimes, but not that often. What I found compelling, I conclude with this about what Lainey has devised, is it devotes all your lawyer's time and all your client's time to actually solving problems. And the end result, if you go to lflegal.com, our settlements, which in a number of cases have been made public, they're not court decisions, but to me, they are incredibly powerful precedents for social change. Anyway, let's give a warm thank you to Lainey for her presentation.